Hello everyone. We are here to discussing the two problem solving questions regarding the subject of business and corporate law. We are four members in our group: Diljit Singh, Mamta Rani, Amrit and Prabdeep Kaur. So here I'm discussing the first part that is regarding to the swimming pool company. So the issue regarding this is that can swimming pool company be held liable for the act of Martin? So the rules point last states that employer can very well be held for the act of its employees as defined as various liabilities. The next point is that if employee does something that harms third party related to employer, that can be held liable for the same. Regarding the application point of this company, the company was benefited from the actions of Martin as the money that Martin had earned, a chunk of it went to the company. Furthermore, duty of the company to keep a tab or develop internal process system or that can provide check to such practice. Along with this point, we can add that customers met Martin as an employee of swimming pool. There is various liability and it can be held liable. Regarding the conclusion point, we can discuss that contract that customer would have signed or the deal that customer would have made would be in the name of Martin and swimming pool. Hence, if there has been any breach, the company can be held liable as the law of the court. So for the next part, I would like to call my group member Amrit.
Second issue is there scope for swimming company to claim not to be liable because of Martin? Rules are is the way to argue for the case 1. The same can be seen from the light of Civil Liability Act. This is an act of 2002. As per this law, section 5Q of the Civil Liability Act, there is various liability for the employer. Application is if we refer to the judgment of the case Lister versus Hesley Hall Limited as pronounced by Lord Clyde, he stated that mere presence of employee at the location does not mean employee can be held liable for his crime. He stated that the presence does not mean that employer has authorized employee to commit crime. Hence, swimming pool company cannot be held liable as they did not ask for misinformation from Martin. Moving on to conclusion, referring to the previous case, we can say that swimming pool company cannot be held liable for the crime of Martin. Next will be proceed by my friend Diljit Singh.
Evaluate the liability of the Martin for this act of to the company issue. As I discussed earlier, Martin has committed crime and now we must sustain this liability. Rules. There is no defined law as to how much the damage can be claimed by the employer from the employees for the damage that the has done to the third party, the customer. We have already established that there is the various liability for the employer. However, employer can claim damage depending on the extent of the negligence by the employer in the performing duty. Application providing misleading information to the customer indifferent to the construction of pole. Now these two accounts he can the suit for the first one, which is the negligence as did not perform this duty and due this action many of the customer had suffered. He can sue under the branch of the Contract Crime Act 1990 has been another act under which can be prosecuted for the fraud. The conclusion. Thus, the liability can be set under the negligence of and fraud. He can be held liable of the claim made by the customer as well as money that he owned and it did not give to the company. And please come my next group member Prabdeep Kaur.
Hi, I'm going to explain the next issue. Has there been any breach of the law in the act of the Martin to set up his own business? the issue. By launching his own business, has Martin committed any crime? So the rule, Martin was working with the swimming pool company as marketing executive, and he was interacting with the clients on behalf of the company and had been providing them with the wrong information at the same time he was planning to launch his own business. So when we say this legally, then it is wrong to do so. He cannot work for the company at the same time start a company which is rival to the employer. He had also taken money from the customers on the behalf of the company and had never bothered to deposit them and had kept to himself. This is the fraud in the eyes of the criminal law. So the application, as per the law, we have a situation where an exciting employee has started his own company which is in the same business. As per the employer and the employee contract, if employee working with the employer, he cannot work anything else which is other source of the income, as he is paid for skills by the employer. This crime under the contract of fidelity. Further, he was also siphoning off the money. This is the crime under the Crime Act 1990. Conclusion for this, those as per the contract of the fidelity as well as Crime Act of 1990, we can say that Martin is guilty.